Hello, well, my name is Belinda Jones. I'm a family mediator. I work for my own company and I also work for the Family Mediation Trust based in Cambridge. I'd like to talk today about domestic abuse and mediation, whether it's a contradiction in terms. Now then, there we go. You might have heard recently about the Ministry of Justice proposals, where they're looking at making mediation compulsory as part of when couples want to make an application to court to discuss children matters in particular. They view it that at the moment, too many separating couples currently see the default position as it's going to court, going to solicitors, with all of the costs and stress that involves. So the Ministry of Justice is looking into accelerating this cultural shift for separating couples away from court and helping them to see that mediation can produce outcomes for all family members which are better than those that maybe court can provide. So they're looking at a series of measures at the minute to help separating families, but the caveat is for those alleging domestic violence or domestic abuse. So the question is mediation suitable if domestic abuse is raised? First of all, I think when the legal aid, the LASPO legal aid bill came in the not noughties, the teensies, the intention was to steer more people to mediation. And the only time in which you would receive legal aid funding for court proceedings was if domestic abuse was raised. After that bill came in, we noticed that there was a spike in allegations of domestic abuse. So what we've learned from that is an allegation of domestic abuse may or may not be steeped in fact, and there's a proportionality to the degree of domestic abuse. But it isn't always suitable. So there are a number of reasons, a number of ways in which we understand or know already where mediation is not suitable. So first of all, if there's safeguarding issues regarding children, straight away that's not an issue to be mediated. In that situation, a mediator would provide the court form and close the case. But there are a number of different circumstances when somebody comes to a mediator, either asking for a court form or seeking to mediate. Domestic violence, that's a relatively visible circumstance that can be observed quite often. There have been police call-outs. Obviously, there's visible evidence if someone's been violent. But domestic abuse, there are many forms of domestic abuse. They're not all so visible, and quite a lot of these different forms of abuse are very, very subtle and difficult to assess. The forms of domestic abuse, I'm not sure if you're aware, they can be physical, emotional. I'll make sure I don't leave any out. Psychological, financial, economic, sexual abuse, spiritual abuse, cultural abuse. There's lots and lots of different ways in which one person can control another, and not all of them might be in plain sight. There's been recent case law a few years ago now that is steering courts towards looking at patterns of behaviour. So that's the re-ction notes that basically courts can't just look for one individual example of domestic abuse. Sometimes it's the pattern of behaviour, any one situation which might in itself not look to be particularly serious, but when put into a pattern, you can see that the victim is being abused. The end of any relationship is a very risky time for most domestic abuse victims, and of course that's exactly when they would come to mediation to be talking about children matters and potentially finances. But that's often where you can see signs of stalking, harassment. There's just many different ways in which the victim's circumstances could be exacerbated. And of course, we have to look at those forms of invisible control if they were acted out within the mediation setting. So when mediation, is it suitable in domestic abuse cases? In the right circumstances, based on a mediator's assessment of both parties in the MIAM, the assessment meeting, then the victim can actually be supported to state her case or his case and to be able to achieve a balanced outcome. But in that situation, we need the mediator with the right knowledge, so the right training, first of all, the knowledge and awareness of how domestic abuse presents, the right training and experience, so that they have a sense that they are able to assess accurately, to the best of their ability, what the dynamic is between the two people presenting. the mediator with the right approach, and the right model of mediation. And with the right support going through this process, often victims can claw back some control, build autonomy, and act autonomously within that setting if the mediator is able to support the victim to speak out. But first of all, when is mediation not suitable? Because there definitely are times when mediation is just not suitable. If a decision to mediate is made when it's unsafe to do so, this can have very serious long-term damaging consequences for the victim or survivor. If a mediator effectively supports an abuser to continue the abuse of the victim within the mediation process, that's not going to help anybody. That just makes the situation worse and leaves the victim feeling that there is no help. So there are times when mediation is just not suitable, and a mediator would sign the court form for an application to court. So as mentioned earlier, safeguarding consent for children, that's absolutely not the remit of mediation. Also, if the victim's not ready or not supported in any way, so do they understand the relationship they've come out of? Do they have a new perspective on that relationship? Often victims might come to mediation wanting to mediate when the mediator can see that they clearly are not emotionally ready, and the abuser is still trying to control them. If the abuser has all the power and is still seeking to wield the power, is it likely that a mediator is going to be able to help in that situation? Mediators absolutely get a sense of those cases which are 100% not suitable for mediation, and the court form is the only way out of the situation. But there are many, many grey areas. So when a mediator is assessing for suitability, there are a number of things within that MIAM that we're looking for. MIAMs have to be at least an hour long, and accredited mediators actually, under the new guidance, have to explain if they haven't spent an hour with each party, at least 45 minutes with each party, why they haven't done so. And that's because there's an awful lot of information that can be gleaned in those MIAM assessment meetings to help a mediator work out whether mediation is suitable for this family. So first of all, we're looking at mental capacity, first of all, if they have the autonomy to make the decisions and to carry them through afterwards. If there's been abuse, the form of abuse, as I mentioned earlier, because that is something that we'll be assessing where they are in that process and whether we can help them. Whether alcohol and drugs plays a role, because that's obviously going to be a complicating factor. Looking for the abuse tactics used, so drawing out from the victim just how they have experienced the relationship with the other party. And we speak to both parties. So obviously we speak to the victim and hear their understanding of their circumstances, but we also speak to the alleged abuser to understand their perspective on the relationship, and to drill down with them just how they expect mediation is going to pan out. In that assessment meeting, the mediator would be looking to see, looking to explore with the victim how they would know the victim was finding things difficult, how they present, what their reactions are if they feel that they're struggling, what they would do if that's the case, and also we're looking for their emotional readiness. Have they moved on from the relationship enough to be able to state their case, or are they still very, very controlled by what their former partner feels? We're also looking for safety, not just in the process, but also outside of the process. What will happen once the mediation session has ended? Is there likely to be a knock-on effect for either party and their children? So those grey areas, as I mentioned earlier, the MIAM assessment, we anticipate that it will take up to an hour to draw out what's going on for each party. So we're looking into whether and to what extent abuse has been present in the relationship by asking open, careful, and sensitive questions. The mediator has to do an awful lot of active listening. It's very rare for any one case to be black and white at MIAM stage. And we're looking to assess the impact of the abuse on the victim and survivor and where they are on their path to recovery. So here's an example. You see two clients before you. One, there's been one incident of physical abuse when the separation was ended. One party pushed the other, they fell, hit their head on the way to the floor. Police were called out, so there's absolutely an allegation of domestic abuse and domestic violence. There's been a year since separation of controlling behaviour as the relationship deteriorated, and eventually one of the parents leaves home with the children. Since then, the children have been spending overnights with the other parent, but they're starting to say that they don't want to spend time overnight with that parent any longer. The two separate outcomes that we have here make for very different scenarios within the mediation setting. So if the parent threatening to harm is threatening to harm the children, is going to call social services if the victim doesn't do what they say. There are threatening tests. It's very abusive. It's only it's only been a few months since the separation. That leads to one outcome. A mediator would be very unlikely to consider that suitable for mediation. However, if we were 3 years down the line, the other parent had always had a strong bond with the children. There'd been therapy it had taken place for either or both of them, and the victim was no longer fearful and felt more empowered to have a positive conversation with the other parent. That's a circumstance where a mediator might well decide that mediation is suitable, and that could possibly lead to a much more positive outcome than re-traumatising everybody through the court process. So the mediation models, going back to what I said earlier, if you have the right mediator, the right circumstances, then what is the right model? Which is the right approach? Mediation tends to be, the default position is face-to-face, both of you in a room together discussing matters. Since the pandemic, that's obviously moved to both people being online in many circumstances. So mediation can be in two people in a room together. Quite often it can be online. The online option allows for a little bit less of the physical presence, which sometimes, in my opinion, in domestic abuse cases can be really helpful. There's less of that sort of fear of the physical stature of the former partner. Face-to-face sometimes isn't the right approach, because if a victim is easily sent into fight or flight or freeze and can't think clearly once triggered by something said by the other party, they're not going to be able to mediate. They're not going to be in the right frame of mind. And in those circumstances, shuttle mediation can be really, really helpful. The mediator moves between the two parties and is able to present what is being said to each party without the emotional triggers. Online can be really helpful, because you can put people in that people are in different spaces. We can still use the mute button if someone's talking and they refuse to stop talking, but obviously we can turn off cameras and microphones and take a pause. That I find is really helpful in many situations where there has been domestic abuse, but where both parties are trying to move forward. Hybrid mediation is another alternative where the mediator is able to hold confidences between both parties. So they're not able to hold confidences in relation to facts such as financial disclosure, but the victim can talk about how they're feeling and how this situation is affecting them, and the mediator can take just the message back to the abuser, rather than the victim showing how they feel and not wanting to be seen to be weak in front of a former partner again. But the question is always, is mediation safe and suitable, and what is the potential likely outcome for clients? At the mediation, particularly at the MIAM, signposting is a really important phase for mediation. The mediator, when assessing for mediation, will be looking at where the victim is on their journey to recovery, and always considering what potential other services might benefit them. The mediator is looking to see whether they've received support already, who that's come from, and quite often signposting that it might be appropriate to return to a domestic abuse service when perhaps they've spoken to someone at the point of separation, but a year or two down the line they're still struggling to some extent to move the situation forward, and don't have the objective oversight of their circumstances to see that they're not completely out the other side yet. Obviously, there's also, we would signpost to other support, such as citizens' advice if they need financial advice, legal advice, and making sure that victims are always considering whether some sort of domestic support service is relevant for them. So, finding the right mediator. all mediators have training and screening in assessing for domestic abuse. That's something that that is part of the training of mediator and part of our ongoing training. However, some mediators might take a specific interest in this area of work and do more ongoing training and have qualifications that equip them to drill down further and to support clients through this process. If you were considering on behalf of a client, or if you knew someone who was considering whether mediation would be suitable and which mediator to use, it would be always helpful to ask the mediator how they approach domestic abuse. This is very much a part of the MIAM assessment before you move forward into mediation, is what would happen if things go wrong within that process, what would happen if things are difficult within that process. We're at a point now where domestic abuse services are starting to work with mediation services. That's the MADAN reference at the bottom. That's the Mediation and Domestic Abuse Network, where domestic abuse practitioners and mediators are coming together to try and work together with one another. It has always been in the past the case that people thought that mediation and domestic abuse are not compatible. Nowadays, we're starting to understand that for a victim of domestic abuse, if they are able to be supported, they can have the domestic abuse domestic violence practitioner with them if they want to within the process, either in shuttle or in face-to-face, depending on the agreement of both parties. But nowadays we're starting to understand that it can be less traumatizing for a victim of domestic abuse and domestic violence to be able to indirectly have a conversation rather than being taken through the court process, which is re-traumatizing for most people in most circumstances. They don't necessarily have to confront their victim. They don't have to go to a court building and be there. They don't have to hear the allegations against them because as mediators, we know that it's not always the victims that make allegations. Sometimes perpetrators are the ones making the very same allegations of their victims. So at times, within the right framework, having assessed the circumstances of the family and where both people are within their journey out of the relationship and towards recovery, sometimes mediation can be the very best outcome for that family. A final note I'd like to make is there've been a couple of pilot schemes in North Wales and down on the South Coast, looking into how courts can work with mediators and domestic abuse practitioners to see if there's a joined up approach. And I suspect we'll be hearing more about how the different the court, mediators, domestic abuse services are all working together to try and support outcomes for families in the future. That's everything from me. I don't know if anybody's got any questions.
Do you want to stop sharing and come back on?
Yes, thank you. Good point. Thank you.
Did you say that the IDVA could go into mediation as well as into court?
It needs to be agreed by both parties, but in a shuttle situation, it's more likely to be agreed just because both people aren't together anyway. So yes, it's something that would need to be agreed. So I think both parties would need to be able to be at some point along the journey where they would agree that. I think if you had a perpetrator who was still trying to control everything, the likelihood might be that they wouldn't agree. But in many circumstances, yeah, it's allowed. The classic mediation model allows for other people to support both parties within the process. So you can have solicitors helping you in the mediation process, and you can have financial advisors, for example. So it's the same rule for domestic abuse support. But always it has to be agreed by both parties.